Some parents choose to send their children to private schools or prefer to homeschool, and they might ask, what about my kids? Are they entitled to special education services? The answer, in general, is yes. The local and state education agencies have the responsibility to provide special education services to non-public school children. The word private school is avoided in Nebraska's Rule 51. These services must be equitable, that is, similar to those it provides for their public school children. However, federal law leaves extensive latitude to individual states to develop their own regulations with regard to coordination of services between public and non-public schools. And here in Nebraska, the rules are particularly complex. Nebraska's Technical Assistance Document covering non-public placement is available upon request from PTI Nebraska by calling 800-284-8520. These general rules apply for children enrolled in private schools by their parents. 1. Federal dollar amounts spent on special education services for children in non-public schools should be proportional to the federal funds made available to the local school district for all children with disabilities in the district. 2. To determine the proportion of those funds, and as part of its child find responsibilities, the local school district coordinates with private schools to locate and count the number of children with disabilities residing within its district. 3. Services to non-public school children may be provided on the premises of private schools, including religious schools, as long as it remains consistent with other laws. 4. State and local funds may augment but not replace the proportional federal funds required to be spent under the law. 5. Each local school district must maintain records of the number of children evaluated, the number of children determined to be eligible, and the number of children served among the population of non-public school children. 6. Equitable services, meaning similar but not necessarily the same services, are to be provided to non-public school children either directly by the public school district or by contracting with an individual, association, or private agency to provide those services. 7. All services, including materials and equipment, are to be secular, neutral, and non-ideological. 8. The public school district is to control the funds used to provide special education and related services to non-public school children, and title to all materials, equipment, and property purchased with those funds remains with the school district, not the non-public institution. When the parents, by choice, enroll their child in a private school, the parents, of course, will bear the burden of the normal cost of a non-public school education. The local school district assumes only those costs associated with providing special education services to the non-public school. If, on the other hand, a child is placed in or referred to a non-public school by the state or the public school system as the means of carrying out its obligation to the child, the cost of enrollment in the non-public institution is borne by the school district. In those instances, the state education agency will determine whether the non-public institution complies with state standards and whether children enrolled there have all the same rights as those enrolled in public schools. When determining who pays for enrollment in a non-public institution, it's not uncommon for disputes to arise between parents and their public school district. The law weighs in here with some specific examples. The public school system is not required to pay for the cost of even special education and related services for a child attending a non-public school if the public school had first made available to the child a free, appropriate public education in their own facility, and the parents later elected to place the child in a private school or facility. In other words, the public school system is obligated merely to provide the child with a free, appropriate public education. It is not obligated to put the child through a private school at the parent's whim. However, the parents may seek reimbursement for the cost of enrollment in a non-public institution if a court or hearing officer determines that the public school system had not made a free, appropriate public education available to the child in a timely manner prior to that enrollment. This would require the parents to undertake a proceeding against the school district known as a due process hearing, which we'll cover a little later. In determining the validity of the parent's claim to reimbursement, the hearing officer will look for evidence of unreasonableness with respect to the actions of the parents, and if found, reimbursement could be reduced or even denied. Examples in the law of unreasonableness include 1. At the most recent IEP meeting prior to removal of the child from public school, the parents failed to inform the IEP team that they were rejecting the proposed placement of their child, failed to state their concerns, and did not announce their intent to enroll the child in a non-public institution at public expense. 2. The parents failed to give written notice of their intent 10 days before the child's removal from public school. 3. The parents failed to make the child available for a re-evaluation requested by the school district. Many other factors enter the equation when the non-public school into which the child is enrolled is not located within the school district in which the child resides. For greater depth of coverage of Nebraska's laws governing special education services in non-public schools, contact PTI Nebraska directly at 800-284-8520. This concludes Part 9 of Bright Ideas. Parts 10 and 11 will cover the extremely important topic of dispute resolution.